Well, good morning, everybody. How are you? Thank you for your participation today. My name is Scott Clements, and I'm with the Community Associations Institute Greater Orange County Chapter. I'm joined today by Diane Peters with the Delphi Law Group and AJ Scott with Klein Insurance Group. And we're here today to talk about homeowners associations and the things that we believe realtors should know before listing and selling in a homeowners association. Give you a little background. CAI was founded in 1993 right here in Orange County. It has grown to over 64 chapters worldwide. It has about 40,000 members. We represent the Orange County chapter, which has about 1,500 members here in our beautiful county, just as yours. We are dedicated to the sole purpose of benefiting those that live in homeowners associations. We have memberships of all types. We have consumer members, people that live, buy, purchase in homeowners associations. We have the business partners, people who manage, who sell services to people in those communities. And then, of course, the individuals themselves that make up the management of the association. So we're a lot like the Orange County Realtors. We're a group of people who focus on one issue, but we have a lot of members in common, and we have a lot of professional service providers in common. So we want to make you aware of the resources that are available to you and your clients through CAI. And by the way, most of it is available free of charge on our website. Okay, here we go. Apologize for that. So we wanted to make you aware of what you've been told 1,000 times by your broker versus Eastman versus Strasburger. And my point on Eastman Strasburger is that they accuse the realtors in that case of being lazy, not corrupt. So it's important when you're working with a buyer or seller, particularly a buyer, to make sure that they have all the information that they need to make an informed purchase decision. And that was the essence of Easton Strasburger. And then, of course, you have your own duties that are outlined in the Civil Code as noted as above. And I'm not going to bore you with reading it to you. You're aware of them. What I want to make you aware of is how you can integrate your duties as a real estate professional and the information that you should be aware of. And I've listed it here. And through the next 2 hours, we're going to explain the importance of all of these. But first off, you want to make an effort to ensure your clients have copies of all the important documents. That includes the CC&ERs, any policies such as parking, etc., dogs, pets, all that stuff. Useful information about the budgets, reserve studies, financial disclosures, all of that is available. It's available through Section 5200 of the Civil Code. We're going to talk a lot today about the Davis-Sterling Act, which is a part of that Civil Code, and we're going to have some sections in that. We also recommend that you make an effort to ensure your clients understand the use restrictions and community policies, such as those pet restrictions, parking restrictions, community activities that they can and can't do, everything from flying flags and so forth. So you want to make sure you're aware of all of those uses because, of course, particularly today with Airbnb, short-term rentals, if that's a possibility, you want to make sure your clients have a good expectation of what they can and can't do when they purchase into these communities. And then you want to make sure you have a good financial picture. And we're going to explain how to do that through the reserve study, your operating budgets, and the financial elements that are available to the members to evaluate before they purchase into these communities. And last but not least, we want to make sure that you're properly insured. So of course, the homeowners association is insured itself, but there's still insurance needs for the individual unit owner, and those are going to vary greatly by individual circumstances. So we're going to talk a little bit about how to identify those, and of course, recommend that they seek the services of a professional service provider in that regard. And so with that, we will turn it over to Diane. She is, as I mentioned, with the Delphi Law Group.
Hi. As Scott mentioned, my name is Diane Peters. I'm an attorney with the Delphi Law Group. Is my screen showing there? I guess I'm not on the right slide though. Let me catch up. There we go.
It looks perfect.
So I'm going to jump. Awesome. Thank you, AJ. So I'm going to jump in with the law section. So basically just cover some of the basics of home ownership in an HOA and some of the terms you might hear being thrown around in the HOA setting and those legal terms and things like that. And as Scott mentioned, go over some of the governing documents and policies that will be governing the separate interest that is purchased within an HOA. So it's a lot to cover, but here we go. So first we're going to touch on just the definitions of the common interest development types. I'm sure you've all heard of the condominium. It's a legal form of ownership where each owner actually owns his unit, which may be just consisting of the airspace, and then the rest of the area is considered the common area. So it's owned as in an undivided interest with the other owners as tenants in common. So as we have here, it usually consists of the building structure and components. It can consist of a garage, any type of common facilities, recreational areas, things like that. So, but each definition of a unit will be a little bit different. So you want to look at condo plans or CC&Rs to understand what your client is actually going to be owning if they do purchase a unit in a condominium development. And the other type is a planned development. So these are typically the single family homes that are owned on a lot. You can see kind of a picture there of a tract map. It's a legal form of ownership where the owner owns the lot and the residential structure located on that lot. Now, being in an HOA, there is still typically some sort of a common area. So again, that might be a common landscaping area, might be public streets, sidewalks, again, any kind of recreational areas, things of that nature that the HOA is responsible to maintain. And then we have a couple other lesser known types of common interest developments. You may have heard of them. So we have community apartment projects. Those are usually where you have a right to an exclusive occupancy of an apartment, as well as an undivided interest in the development as a whole. And then there are stock cooperatives, and those are usually where the apartments and the common area are owned by the corporation. So they're owned by the association, and the owners have an exclusive right of occupancy in those apartments. So they're a little bit lesser known, but they're out there. So just want to make you aware of those. And we have a note here about a townhouse. So a townhouse isn't a separate entity, a separate definition. It's not a legal form. It's just it's a marketing and construction term. A townhouse is can either be a condominium or a planned unit development. So you really do need to look at your documents, usually a condo plan or tract map, to determine what this townhouse is really considered. Is it on a lot? Some of them are on actual lots where you own the lot and the land and the structure, and some are more on the condominium side where it's they're next to each other, and the association maintains the structure and the owner only owns the airspace or the interior surfaces. So really just things to look out for. You might not at first blush notice, or your client may not notice when you're looking at that type of separate interest, what that ownership interest actually consists of. So it is really important to look at the documents so that you can inform your client what they should be expecting as far as their ownership interest, and B, their maintenance interest and things like that. So it's good to determine the differences there. Now we're going to move on to the types of legal authority that govern common interest development. So as Scott kind of mentioned in his opening, there is this entire area of law called the Davis-Sterling Common Interest Development Act, and it's only in California. It applies to California common interest developments, and then it's this entire area of law that governs how community associations operate. As you can see here, it covers maintenance. So if the documents are silent, it will cover who is responsible, the association or the owner, for certain maintenance elements of the common interest development. It covers assessments, minimum insurance limits, construction defect claims, and then it also goes into things that are typically in your bylaws, such as the membership voting, what it means to be a member in the association, and the rights of that membership, and of course, copying and inspection of records, board meetings, member discipline, enforcement, things like that. So all things that your client really should be aware of before purchasing within a common interest development, because these will affect their rights and interests with regard to their property. So we put this in here. A really good guide, if you want to have one on hand, is the Condominium Blue Book. These really help to, it's kind of like I guess, what is it, like a Cliff Notes. You can really access the law pretty easily, and you don't have to go Google the code section. It lays it out for you. So it's just a handy guide to have, to keep at your desk or whatever, so that you can refer to it. Another source of authority is the Corporations Code. So along with the Davis-Sterling Act, a lot of the corporate governance side for the board is governed under the Corporations Code. So as it states here, most associations in California are formed as California nonprofit mutual benefit corporations. And so there are certain areas of the Corporations Code that apply directly to these type of nonprofit mutual benefit corporations. And as you can see here, it starts at 5100, and it governs the association elections and voting issues. It also has important sections regarding the business judgment rule and things of that nature. So just, again, things to be aware of for the corporation. The board does act as like the corporate board for the association. So they do make decisions, on behalf of the association as a whole. So I know sometimes boards get bad raps, depends on the association you're in, but just something to be aware of, that the board does have that power of a corporate board, a little bit different because of the nonprofit mutual benefit status, but along those same lines. All right, moving along. So also something to be aware of is the vehicle code. This is important because one of the biggest issues we actually see in our common interest developments are fights over parking, because parking is such a big commodity here in California, because there aren't a lot of parking spots, and especially, if you're in a condominium development or if you're near the coast, things like that, parking is definitely something to be concerned about. So it is important to realize that the associations are governed. They do have rights to tow vehicles under this section here, 22-658. And basically it's, I'm not going to go too much into it, but it's something to let your clients, be aware of, that they do need to follow the parking procedures outlined in the governing documents for that association, because the association does have authority to tow if they follow the requirements under this vehicle code section. So again, if they have multiple cars, maybe it's a large family and they're looking in a community that doesn't allow parking on the streets, that could be an issue, and it could be something that they do need to think about before purchasing in that community, because parking, as I said, does come up and does seem to be a pretty contentious issue pretty often in our communities. So you do want to make sure that they're aware of the parking rules and the ability of the association to tow in that case. All right. So health and safety code also pertains to these associations. They are subject to various laws regarding health and safety, and then especially, regarding those that are daycare centers. So it is important that your clients are aware that daycare centers are allowed to be operated within an association. It's a use that's protected under California law of that separate interest. So something to keep in mind. Again, it might have an impact on parking. It might have an impact on noise if there's a daycare center, on your same street, or even if it's your neighbor. But things to know that is a protection. Other things to be aware of is adult or elder care along the same lines as the daycare centers. Those are protected uses of a separate interest within a common interest development. And sober living homes. That one's we've seen a big rise in issues pertaining to those because those are also protected. You know, there are ways to get around, to get at things if there are nuisances caused by these things, by these uses, things like that. But it is just something you do want to be aware of, you know, maybe questions to ask the board or the association if they're aware of any of these kinds of uses within the association, and if it might affect the property your client is looking at within that association. And also, of course, health and safety. If there are pools in your association, it applies to those pools, the maintenance of them, you know, the cleanliness, the certain temperatures, things like that, the chemical levels, they are required to keep those at certain levels, and any other type of common recreational facilities that might be in the common interest development, those kind of regulations and laws would apply to those as well. So again, just a couple other things to keep in mind when you're looking at properties. So a couple other sources here, federal laws that apply to common interest development. The first one is the ADA. So the ADA doesn't usually apply, but we put this in here because sometimes it does. If there are things in the community, like we just talked about, that might be considered to open the association to the public, to public use, like possibly a daycare, elder care facility, things like that, then the ADA might apply to that association, and the association would have to comply with the requirements under the ADA, including making sure the facilities are ADA compliant, that they allow the use for any kind of disabled person, and they have the proper installations. Now, again, if your client is someone who's concerned about this, again, it may or may not apply. So don't expect that all of the common facilities will be ADA compliant if they're not open to the public. They may not be considered part of the ADA. So just again, questions to ask when you're looking at a property in a common interest development. So the other types are the Fair Housing Amendments Act. Now, this is generally the DFE-8. This prohibits discrimination on familial status and age, as well as other things that may be discriminated against in housing. Again, governing documents should not have anything that has any type of an age restriction, unless it's a 55 and older community. That's one exception that is permitted under California law. But and anything that may be considered, and like I said, an age restriction, such as no playing in the streets, so anything that might be geared towards not allowing kids in the community would be considered an age restriction, like all occupants must be 16 or older, things like that. That's discrimination based on familial status. So just things to look out for that associations should not have in their governing documents or in their rules and regulations. So again, as I said, just looking out for things that may inadvertently target children, adult-only pools, things like that. Again, it doesn't have to be explicit, where it doesn't have to explicitly say no children 16 and older. It could be a rule or a policy or a part of the CC&Rs that implicitly would not really be conducive to children or any other kind of familial status in the association. again, just not just limited to that, all types of discrimination really apply here, but those are the main ones we kind of see, the inadvertent familial status discrimination. Also to be aware, the bankruptcy code does apply, of course, if there are a client that goes, has to file for bankruptcy. There are procedures, particularly to the association. The association usually has an interest in the separate interest. If they're filing for bankruptcy, they probably weren't paying their assessments on time. So the association may have the ability to lien the property and would have an interest and be part of those bankruptcy proceedings. Again, you guys probably aren't dealing with this so much, but it's something for your client to be aware of, that, the association does have the ability to lien and possibly foreclose on their property if they aren't paying their assessments. So along with understanding how much principal and interest and property, taxes your client is going to be required to pay for that separate interest, it is important to also look at the other piece, which is the HOA fees. So sometimes they're pretty affordable, and sometimes they can be something a little bit more expensive depending on the amenities and the types of common interest or common facilities, in that association. So just another piece of the puzzle for you to make your client aware of, so they can see the whole picture. And they are required to pay those assessments. They can't just ignore them and only pay their mortgage. And that kind of goes along with the Fair Debt Collection Practices Act. The association is subject to that because they are debt collectors collecting those association assessments under that provision. All right, and case law, another type of legal authority that affects the association. Case law contains the interpretation of the law. So sometimes it fills in gaps of statutes or expands on a statute. Sometimes statutes are written in response to a case law decision. So these are important for you to be aware of, because they do affect the governance, the maintenance, the use of the association property. So if you have any questions about how certain facts are interpreted or guidance, case law is a good way to kind of look at how the courts have handled a set of facts presented to it, and how the court has applied the law to a set of facts as well. So, so documents that govern common interest development. So the governing documents. So we just discussed the laws, the California laws, federal laws that affect the common interest development. Now, the most important part, I guess not important, equally important, but these are particular to the common interest development that you will be looking at. So it'll apply directly to the property. And, the governing documents Scott mentioned in the opening are things that really govern the use and things to be aware of and make your client aware of, because oftentimes we do, you do have this idea that I own this property, I can do whatever I want. It's kind of like that American ideal of owning property. But if you are purchasing in a common interest development, the association does have the right to limit some of your uses, and those are you are put on notice in your governing documents of those uses. So it is important to let your clients know. Make all of the documents available to your clients, so they have a chance to review them and understand what they can and cannot do with their new property. Again, these governing documents can govern anything from parking, the number of parking in driveways, garages, streets, things like that, to what type of architectural improvements you can make to your home. So a client might be wanting to purchase a home and has these big ideas of adding a second story or adding a giant deck to the backyard, whatever it may be, they really do need to make sure they look at the architectural provisions to make sure that it's something that they can actually do. Maybe they want to paint their house purple, I'm not sure, but again, something that they need to make sure, if they have these big dreams for this property, to make sure that these are something that they can do and they don't get locked into this property and then find out later that the documents don't allow them to make the changes that they really want to make. So the governing documents that create a common interest development, if you will, consist of the articles of incorporation, the CC&Rs, the bylaws, either the subdivision map or the condominium plan, and the rules and regulations, policies, things like that. All right. So we're going to start with the declaration of covenants, conditions, and restrictions, the CC&Rs. So these are recorded documents. They're created by the developer. They're, again, when we say recorded document, we mean that they're recorded in the county that the property is located. What this means, legally speaking, is that even if you don't know that they're recorded or you don't read them, if you own a property within a common interest development, you're presumed to know because of this constructive notice or knowledge. This constructive notice, it means that because it's recorded, it's a public document, your client or whoever's owning property in the common interest development is presumed to know what is in the CC&Rs, whether they've read them or know they exist or not. So it is important, again, that you direct your clients to really read the CC&Rs before they purchase within the association. And these run with the land. So it's not just with the first home. Every subsequent home is then held to those recorded CC&Rs. Changes can be made to the CC&Rs, but it can only be made through a membership vote. And as the theme here, these do contain restrictions, as you can tell by the name, including use restrictions, ownership restrictions, assessments. Again, architectural restrictions might be in here. Other things to look for might be pet restrictions. If your client has, 3 or 4 big dogs, you might want to look at these. They might have a weight restriction. They might have a number of pets restriction in the association. So those are important things to look for too. Again, as I used the example earlier, parking restrictions are always important to look at if there are a number of vehicles, things of that nature to look for in the CC&Rs. Again, to look for in the CC&Rs, I already talked about this, the covenants, because they're recorded, but the case law has found that because they are recorded, they are given a presumption of reasonableness. So what that means, legally speaking, is that they are presumed to be reasonable unless an owner can prove that they are not. The burden of proof is on the owner to show that the CC&Rs are not reasonable. So that's a pretty high standard. So again, as I said, make sure that your client does understand the CC&Rs or at least reads them. Sometimes the CC&Rs don't always make sense. They're written by lawyers who, use a lot of legalese sometimes. So it is important that they try to read them and understand them. If they need to hire a lawyer to understand what their rights are under the CC&Rs, that might be something they want to do as well, especially if they have a specific use for that property in mind, or something that I use the example as the architectural, but if they have other uses in mind for that property, just to make sure that they're aware of what they can and cannot do, and if the CCNRs either prohibit or limit, that use that they might have in mind for that property. So another source of the legal authority is the condominium plan. Obviously, these apply to the condominium project. So these show the engineering specifications. These are also recorded with the county recorder. So these do have the same constructive notice standard as the CCNRs. These often have definitions for the separate interest, for the common area, and for what's called exclusive use common area, which might be, the unit is composed of the airspace. Owners may have a balcony or a patio or a garage space or parking space that's considered part of their exclusive use common area. So they get to use it to the exclusion of others. Other owners can't park in their space or come hang out on their patio, but it isn't considered part of their unit, their separate interest. So understanding, again, the ownership that your client is purchasing into is really important. If they really, want to make sure that they own certain elements and they not exclusive use of some of these elements, or if they're worried about maintenance for some of these elements, it is important that you look at these documents to understand the full picture. And again, that was a condominium plan. If you're in a PUD, there's usually a final subdivision or tract map that shows the lot, the common area dimensions, and for the planned development. Again, there may be easements recorded on the tract map. Basically, it draws up the boundaries of the association, and it's submitted to the city for approval before the development is constructed. So it shows the general area where the condominiums will be, just like the condominium plan. It is also recorded with the county recorder prior to construction. And it lists and describes, as I said, the easements and rights and responsibilities of various parties. So again, there may be easements to the city and other things that, may or may not affect your client's interest. So another type of legal authority is the Articles of Incorporation. These are what are considered the corporate charter. It really depends on sometimes we see Articles of Incorporation that have a bunch of clauses and a bunch of rights. They describe membership rights, things like that. Sometimes they're pretty simple and just outline that they are, this association is being created and has just the basics. So you can always look these up on the Secretary of State's website for the association. They are filed. They do have the true and correct legal name of the corporation. So sometimes we see a lot of track number 12345 Homeowners Association, and that's the legal name, but they don't call themselves that. They call themselves the Vista del Flores Association. So if you are trying to look up the corporation for any reason, go to the Articles of Incorporation to get that legal name of the association. Again, provides the information regarding the location and address of the person within the project for purposes of communication. So those are just, the legal requirements to file the articles under in California. The bylaws. So the bylaws are basically the operating plan for the corporation. So it's how do we run the corporate? How does the board run the corporation? How does the corporate structure look like? Things like that. Includes information on the number and terms of directors, document inspection rights. Usually we'll have the voting rights, information about the annual meetings, disclosure, things like that. Sometimes includes member discipline rights and voting rights and procedures. But look to both the bylaws and the CC&Rs for those the member discipline rights and things like that. The bylaws are not required to be recorded or filed, but some are filed as exhibits to the CC&Rs. But so again, these are something that you won't be able to get from the county recorder. You do need to get from the seller so that you can review the bylaws prior to purchasing, because you won't be able to find them anywhere else or from the board, the association board. Yeah. All right, and another source of legal authority is the rules and regulations. So these are, again, usually will kind of expand on and fill in gaps that the CC&Rs and bylaws for things that aren't contained in the CC&R and bylaws. These are policies, rules, guidelines that are adopted or changes made by the board of directors. These are subject to, it's actually a 28-day notice. Sorry for that typo. 28-day notice requirement under Civil Code 4360. So what that means is the procedure is the board wants to adopt some sort of rule, procedure, policy. They will send it out to a membership vote. The members will have the chance to review and comment on that rule change or adoption. They can let the board know if they have any issues with it, if they have any comments on it, any proposed changes, and then the board will review those comments and adopt and vote on adoption at an open board meeting and inform the membership within 15 days of the rule adoption. So again, this is a little bit easier of a procedure for the board to engage in than going out for a membership vote to amend the CC&Rs or a membership vote to amend the bylaws. So as I stated, you'll often see these that will really fill in the gaps, go into a little bit more minutia. So maybe the CC&Rs will state, to use our parking example, the CC&Rs will state, no parking on the street overnight, but the rules and regulations will say, the speed limit within the association is 10 miles per hour. You may not park on the street. Maybe it'll address RV parking. Maybe it'll address commercial vehicle parking, whether it allows those for a certain amount of time or prohibits them altogether, things like that. So again, it goes into a little bit more detail regarding some of the requirements. Again, maybe it'll address pets. We see a lot of CC&Rs that will say that an owner may have a reasonable number of pets, but it doesn't actually define what that reasonable number is. So oftentimes we will see that in the CC&Rs, and then boards will adopt maybe a 2 or 3 pet policy in their rules and regulations. So that's where you will see that reasonable number is defined in the rules and regulations. So again, it is important to look at both, because if, again, you have that client with the 5 big dogs and it says reasonable number, that client says, yeah, 5's reasonable. Everyone loves dogs. But you don't look at the rules and regulations that then say, reasonable means 2 pets under 50 pounds. So it is important to look at both to get the complete picture of the restrictions that your client will be held to on their property. Okay. That's all I have on this slide. So moving on to enforcement. Enforcement is basically, if we talked about all of the, use restrictions, things of that nature that someone may be held to within a common interest development. And the enforcement side is how boards, associations can enforce those procedures against any violating owners. So again, these are procedures. They usually are adopted as procedures and guidelines. It'll have like usually there'll be a basic outline in the CC&R giving the association and the board the right to enforce, and maybe restating the general law of enforcement. But again, they should have a separate procedure, maybe an enforcement policy and a fine schedule that you will want to look for. And that's where it really lays out what the, I guess, consequences are for violating the governing documents. You'll usually see something that is, first offense, maybe a warning letter. Second offense, you might be subject to a fine. There also needs to be notice and hearing procedures before anyone in a common interest development can be in an association can be fined. The board does need to provide notice and the opportunity to be heard. So that's usually calling that owner into a hearing, which we'll get into a little bit more on the next slide. I'm getting ahead of myself here. So again, as I said, it might be violation letters, might be that first step. So usually if you see a violation letter, maybe it's for landscaping, maybe it's for parking. That means they're just saying, hey, you're violating our governing documents, cure this violation, usually give you a 30-day period to cure. And as I said, I was getting ahead of myself. So hearings and fines, if you do get that violation letter, you fail to cure that violation and you're not in compliance with the governing documents, then the board may send you that notice and invite you to a hearing. Again, before you are fined anything, it should be laid out in your enforcement policy. There should be a fine schedule. Sometimes it's an escalating fine schedule, so it'll be $50 for the first instant. If it continues, the board may escalate to 100, 200, whatever it may be. There may be escalating. Just again, something to be aware of, especially for short-term rentals. We do see some of our clients imposing higher fines for short-term rentals because sometimes a $50 fine on a pretty lucrative short-term rental isn't really a deterrent. The owner will cut their losses and say, I will just pay that $50 fine and keep renting out my condo, whatever it is, on the short-term basis because I'm making so much money renting this out on a short-term rental. So we have noticed some associations having higher fines that can be $500, $1,000, $2,000, depending on the area you're in for these violations of the short-term rental provisions. So again, something to look out for. If your client is looking to purchase in a community and maybe it's near the beach and they're thinking, great, this will be a perfect Airbnb property. They do need to look at what are the short-term rental, what are the rental restrictions, and what are the fines and things like that. So again, something to be aware of. More enforcement procedures, a little bit more escalated beyond that hearing, maybe is the informal dispute resolution. It's also known as IDR for short. The duties of the association is to provide a fair, reasonable, expeditious procedure for resolving a dispute. So the IDR procedures can be invoked either by the association or by an owner. If an owner asks for an IDR, usually asks for meetings in front of the board to discuss a violation or an issue, the association does need to accept that offer. And the association is held to certain standards as set out in 5915 or as adopted in their own enforcement procedure. Try to miss anything. Yeah, this is kind of an in-between before escalating to an ADR, which is on the next slide. So alternative dispute resolution, ADR, is a legal enforcement, including, and it can include mediation or arbitration, and the arbitration can be binding or non-binding. Now, association must offer ADR in writing before it can initiate a lawsuit. So this is important because you can't, the owner can't just be sued. You know, they're violating, obviously they've probably been sent a violation letter. They may have been fined a couple of times, but they can't all of a sudden be slapped with a suit. They do need to attempt to engage in the association is required to attempt to engage in ADR before filing that before initiating a lawsuit. Applies to, but it does apply only to declaratory or injunctive relief and less than $10,000. So the association does need to get like a TRO for something, then they do not have to go through the ADR process. But it is usually for enforcing the governing documents would be part of a declaratory or injunctive relief. And just, again, something to be aware of, and to, I mean, you as maybe a homeowner or your clients, the court may consider a party's refusal to participate in ADR when considering awarding attorney's fees. So again, as I stated, the association is required to engage in ADR. The owner does or does not. They don't have to accept the ADR, but they should, because they don't want that to be considered negatively against them when a judge is considering awarding attorney's fees and costs. So something to think about. Now, mediation, usually there is a mediator, and that person serves more as like a referee, kind of trying to get the sides to come together to reach a mutual understanding or mutual agreed upon outcome to the issues. The mediator isn't making any decisions. Again, I say you want to think of this mediator as a referee, basically, of the dispute. While arbitration is, the arbitrator can make a legally binding or non-binding decision on the outcome. So they serve more as like a judge position, where each side presents their case and the arbitrator will weigh the evidence and make a decision. Again, we generally, mediation, you know, if it's something you think you can come to I guess an agreement upon, or you think it might just be a misunderstanding between the two parties, mediator is really helpful in resolving something like that. Arbitration, where there might be one party is being a little bit more stubborn, and you really just need to get a legal decision on that. All right. So enforcement, moving on, lawsuits against homeowners. So as I said in the last slide, for declaratory or injunctive relief, the association does need to offer ADR before filing a lawsuit. Temporary restraining order, this might be something, well, let me back up just a minute. So just to overall, an association may be required to bring a lawsuit to enforce the governing documents. As part of the CC&R, is generally one of the duties of the board is to enforce the governing documents against owners. So I don't really know many boards who want to file lawsuits. They generally want to get it resolved before it has to go to the lawsuit. Not only is it expensive, but it's time consuming. It makes a contentious relationship between the owner and the board and the association. They are trying to avoid. However, again, as I said, the board does have the duty to enforce the governing documents. So if the board has tried to engage in the other enforcement remedies, the violation letters, the fines, maybe suspension of privileges, if that's authorized under their governing documents, IDR, ADR, and these remedies haven't worked and the owner is still not in compliance with the governing documents, a board may be not forced, but may be required to bring a lawsuit because the board needs to be consistent. They must treat like cases alike, and if they don't treat like cases alike and they don't follow their own rules, they can lose their ability to enforce, basically. So sometimes you see these association lawsuits that are like, really, you're gonna file a lawsuit over this person not like cutting their grass? I'm just using that as an extreme example, but again, the board usually does not want to be filing that lawsuit, but it's because they've exhausted all other remedies and they are required to enforce the governing documents to get compliance from this owner. If they fail to enforce against one owner, cutting their grass, landscaping, whatever it may be, then the next owner that is in violation may be able to argue that they have not been enforcing that provision of the governing document, and the association may actually lose that ability to enforce that provision of the governing document. So that's usually behind when you see like these boards and associations kind of get vilified for these lawsuits that are being brought. It's usually because they have no choice, and they do need to be bringing that lawsuit to be consistent and not lose that ability. Their obligation is to the corporation first, and they don't want to lose their immunity. So now I'll get into the different types after I kind of went over that reasoning for you. So the temporary restraining order, an example of a temporary restraining order might be someone building a third story, and that's not authorized under the governing documents. So the board, again, in this instance, would not need to go through ADR because the third story building may be built by the time they engage in the ADR process. This is an instance where the board can go directly to the court and ask for a temporary restraining order so that the court can issue an order to prevent the owner from building any further. And so those are usually issued within 24 to 48 hours. And, there will be a hearing in front of the judge within 20 days after the TRO. The court determines whether a preliminary injunction will be issued until the hearing. So that's just how those work. Again, we don't want the owner to be putting in the money and time to complete that third story. And then if the court then orders that they need to remove it, there will be a little bit of an argument there because of the cost incurred on that owner. So that's why an association can go out and get that temporary restraining order. Again, it can turn into the preliminary or permanent injunctive relief depending on the outcome of that court case. The injunctive relief, again, is a mandatory restraining order. So then if court rules on behalf of the association in that case, it would be in our third story building example, it would be restraining, preventing that owner permanently from constructing that third story building, third story to their building. Or injunctive relief can look like, can be stopping someone from doing something, or it can be compelling someone to do something. So our landscaping example, if someone hasn't been performing their landscaping repairs to their lot, it can be an order requiring that the owner maintain their lot, landscape, do certain exterior repairs, things of that nature as well. Damages, again, this is in the case where if there are damages caused and the association had to incur costs on behalf of that owner, they will file a lawsuit for damages. And declaratory relief, that means a court order to interpret the document or meaning of the document. So usually it'll be the interpretation of a provision of the CC&Rs or interpretation of a provision of the bylaws, something like that. The court will say, usually, usually there's a dispute. The association says it means this, the owner is arguing it means this, and the court will make that ultimate decision about what the interpretation of that provision actually means. All right, moving on. Biggest issue in enforcement is legal fees. Now, I've touched on this a bit already. It is a big deterrent on both sides, I will say, to filing lawsuits. Associations, again, they generally do not want to bring lawsuits because it is costly. It is time intensive, things like that. But board, does need to make a decision. As I said in the previous slide, they don't want to lose their ability to enforce. The board has to make a business judgment on whether it is worth it to file the lawsuit. They have to consider the factors such as, again, enforcement. Are they going to lose their ability to enforce? Have they been consistent in enforcing? And of course, another factor is the time, the cost, and things like that in pursuing a lawsuit. Sometimes, again, the association must enforce the CC&Rs, but again, it really depends. The association has to make the best decision on behalf of the association to try it. So usually they try to avoid litigation before it happens using the other remedies we discussed already. The legal fees here do include recovery of attorney's fees, costs, things like that. And there is usually a provision in the CC&Rs that will allow a prevailing party in enforcement action to recover your attorney's fees. Other things to think about are, thinking about looking at maintenance matrix. Maybe an association doesn't have a maintenance matrix. They should maybe add one. If there are provisions that are maybe unclear of who's responsible, owner or association, for certain maintenance items, and that can help eliminate some of the confusion or some of the potential conflicts over those items. Clear lines of communication are always helpful. And, of course, as I said, ultimately the board does need to make a business judgment rule decision on whether or not to pursue a lawsuit. So that is something that they do need to consider before bringing that suit. All right, so enforcement, so defenses to enforcement. Some of the defenses are listed here. I'll try to go through them pretty quickly. I know there's kind of a lot here, but basically the defensive lapses means the board didn't enforce for a number of years. So if they knew or should have known about the violation, but they sat on it, that might be a defense. And sometimes we see this defense where there's a new board and maybe a provision hasn't been enforced in a long time, and all of a sudden the board realizes, hey, our governing documents actually say, you know, XYZ. So we need to be enforcing this. But they haven't been enforcing it. So again, I just mentioned you might lose the ability to enforce. So that might be a defense that an owner has. Another defense is waiver. Again, if they didn't enforce it against one owner, or if they didn't file a lawsuit against one owner for the same violation, but they are enforcing it against another, the association board may have waived their right. They must be consistent in their enforcement. Failure to be consistent can result in a waiver of their right to enforce. Estoppel. So this is where maybe the board said it was okay to do something, and then they do or do not something, and then they change their mind. Or maybe you got an architectural approval for something, but then from the architectural committee, and then you went forward with those architectural improvements, and then the board said, hey, actually the architectural committee shouldn't have approved that. Now we're going to make this owner take out that improvement, or, you know, incur the cost to take it out. That prior approval that they were told it was okay, that might be a defense. Changed conditions, meaning that maybe a rule and regulation made sense 25 years ago, but it doesn't make sense today. An example of that is there actually is a one pet rule in California. So some CC&Rs, some rules and regulations say that no pets can be allowed. If that is a provision under California law, you do have to allow at least one pet. So that could be an example of a changed condition. Selective inconsistent enforcement, I kind of went over that. So if there are multiple violations within the community, but the association is really only targeting one person for those violations, there is a defense that they are being selective or inconsistent in that enforcement. Discrimination, this may arise if a member thinks they are being targeted for enforcement action because of their age, sex, race, things like that, disability, things of that nature that may be a defense. Lack of notice of the rules. So again, we talked about that 28-day notice and comment period before any adoption of rules. If all of a sudden the board is just enforcing a rule that was never sent out, but they said, hey, we adopted it, but it was never sent out for that notice and adoption notice and comment period, then that is a defense because the owners were never put on that notice of the adoption of that rule. And finally, a defense may be a conflict between the governing documents. So again, if the CC&R say one thing and the rules say something else, sometimes the owners don't know which one to rely on, and there may be a conflict there. So moving on, the standards of care. So I think you guys have heard me say this a couple times, but I've mentioned the business judgment rule, and I'm sure you've heard of it. It's a similar kind of fiduciary standard that you have as realtors have to your clients. This is the, I guess, standard of fiduciary care that the association, the board has to the association. So, and if they act under this business judgment rule, the board decisions will be protected generally. So the business judgment rule states that if the board acts in good faith after a reasonable inquiry or investigation and in the best interest of the community, then again, they will be generally protected under this business judgment rule. Again, you may have heard of the business judgment rule in the corporate world, things like that. It's a similar rule from a corporate board has as a fiduciary to their company. But The business judgment rule is generally, again, it's under a reasonably prudent person standard, and it gets a deference standard, meaning that courts are going to grant deference to the decisions of a board when made under the business judgment rule. This deference means they aren't going to go back in time and say, hey, looking back, it was you made the wrong decision, or looking back, maybe this wasn't the best decision. If the board, again, made the decision under the tenets of the business judgment rule, the court will grant grace to that decision, assuming the board made the best decision at the time with the information available to them. This doesn't mean that the decision has to be right. It just has to be made under these tenets. Again, hindsight is always 20/20. So the board doesn't have to be held to making the right decision every time, just as long as the decision is made in good faith, after a reasonable inquiry or investigation, and in the best interest of the community. So I usually like to glom on to the reasonable inquiry or investigation, because that's the part that you really can look at and say, did the board do this or not? Of course, the board will always say, yes, of course our decision was in good faith and we thought it was in the best interest of the community. But did they actually vet this decision? Did they make a reasonable inquiry? Did they think about both sides? Did they get an expert opinion if it's it's applicable in that situation? Did they get a legal opinion? Did they get an arborist opinion? Did they get a CPA opinion when making certain decisions? So those are things that a board can do to kind of insulate themselves from this liability. Again, based on this inquiry, as I said, it can turn out to be wrong, but as long as they engaged in that process and documented their decision, then they will be protected. All right, I think that's all I have for that section. Okay. Transfer disclosure. So California law 4525 through 4545. So this is something that maybe you guys may be overlooked in when you as realtors are looking at the law. Maybe you're not looking at the Davis-Sterling Act. So these provisions are something you should definitely write down, because it is important, especially, as we said, if your client is looking in a common interest development property. So 45, yes, you have it now. So make sure you do reference those too. In 4530, I know this looks really long, but the important part is highlighted for you. But basically you need to make a written request for the documents, and the association will provide them within 10 days. And you can receive by electronic transmission, which means by email or by website. Sometimes the governing documents are posted to an association website, so they may direct you there as well, or you can get them by email. But going down to A6 there, that is what a seller needs to provide to a prospective purchaser. And these documents are specified, again, in 4525, which we'll go to in just a second. And the cost for these documents will be individually itemized, and it'll be the responsibility of the seller to pay the association or the manager, whoever made copies and provided the document to the seller, or excuse me, to the prospective purchaser. So it is something just to be aware of, that, again, there's that 10-day timeline. So I know that might be important when you're looking at properties or getting into escrow and things like that. And as we discussed, these documents are very important. So there might be something in these documents that may make or break that sale. Maybe the owners decide, excuse me, the buyers decide that it's not the property for them after they review these documents. So that's why it is important to start this process so you can get these documents to your client as soon as possible for them to review. And as I said, 4525 has a list of the documents that shall be provided to the prospective purchaser. So we'll get to that list in just a second, but this is a form. This form is actually in the Civil Code. So you can use this form. It's already provided to you. Billing disclosures required under Section 4530 must be in at least 10-point type and substantially follow this outline here. Again, if you look up this section, it is in that section. So you can use that as a guide. And the documents that shall be provided are the CC&Rs, bylaws, operating rules, things we talked about today. And if they have them, age restrictions, rental restrictions, if any, again. And then also things to provide are the annual budget report or summary. These include the reserve study, assessment and reserve funding disclosure summary, financial statement review, assessment enforcement policy, insurance summary, regular assessments, special assessments, whether there's an emergency assessment, any unpaid obligations of the seller, meaning if they're outstanding on their assessments or any other type of fines or anything else that they may owe to the association. Any approved changes that maybe haven't gone into effect yet, but have been approved to assessments. A settlement notice regarding common area defects, obviously, if any. Usually that's probably not something you will get unless they're in active litigation. Preliminary notice of defects, any notices of violation, required statement of fees, and then if requested, you can the minutes from the previous 12 months. So again, these are a lot of different documents. You may not receive all of them, or they may not all be applicable. The important ones to kind of get a picture, and I know that the other speakers will talk more about the insurance provisions and things like that, so I won't get too much into that. But of course, the CC&Rs, the bylaws, the operating rules, the budget is going to be important, the reserve study, the insurance summary, and the assessment, because that will just give a good picture to your client about, again, all of the use restrictions that they will be subject to, some of the rules, how the association operates, and then, you know, any, again, as I mentioned before, the assessments that may not be part of that picture when they're considering the principal and interest of their loan. It's kind of an added expense on top of that, especially if there's, you know, a regular and maybe a special assessment, an emergency assessment, things like that. And just to get a good financial picture of the association, to look at their reserve study. How old is the roof? Is the roof gonna need to be replaced in the next, 5 years? Is there adequate funding in the reserve? Again, I'm not gonna get too much into that. I know our other speakers will be speaking on that, but again, these documents are just important to get that full picture of that property that you're buying into. So I think that is it for me. So I think we're gonna stop if there are any questions on the law portion here.
There were a few. You can look and see if I answered them correctly. The one that was, I guess, more outstanding was apparently there's somebody who's gotten a fine for not complying with an asbestos issue in a co-op, and they're wondering if they could BK on that. My recommendation is probably not. You'd have to see the CC&Rs, but no, I don't know of any CC&Rs that would allow them to get out from under a fine. They're still going to have the collection resources that are available to all HOAs.
Correct. As you said, Scott, it does depend on what their CC&R state. You are, of course, responsible for any fines that are levied against your property, and whether or not it can be liened against your property. The association may seek a judgment that then can be recorded against any property you own, whether it's, oh, I can get out of my share screen. Sorry about that. So yeah, look at your governing documents. It will say what remedies the association has as far as fines, whether they can lien them against your property or not. But again, I can't speak kind of in a vacuum besides giving that general advice on that. But
Thank you very much, Diane.
Perfect.
We appreciate it.
Okay.
Diane's firm, Delphi Law Group, is a member of CAI. If you go to cai.oc.org or CAI.com.
Hi there, I'm AJ Scott. I'm going to be talking to you about insurance, which I know is why you came this morning. The moment you've all been waiting for. But we're going to chat a little bit about the insurance that I think is most important for you all to know and understand as realtors, and try to focus the conversation on those topics that are going to be most important to you and most relevant to your transaction and your sales that you're handling, and how you can advise your clients during that process. So let's just start with the 30,000-foot level. Why do HOAs buy insurance, and what factors really determine what they buy? Because each and every association potentially is going to have quite different insurance provisions. There will certainly be some great similarities, but there may be some nuances as well. So there is specific insurance requirements under state statute, the Davis-Sterling Act, which Diane has introduced us to and which we've been talking about and will continue to talk about throughout the course of this class. So we'll talk about the minimum insurance requirements set forth in those statutes. We'll also talk about CC&R requirements, the governing documents. Sometimes the insurance requirements are in the CC&Rs, sometimes they're in the bylaws. So both documents may be necessary to refer to when you're looking for insurance requirements. Some older associations have very little to no insurance provisions in their governing documents whatsoever. So that is possible. It's rare, but it's possible that there is little insurance guidance in the governing documents. But more often than not, you will find some requirements there. And then, of course, lenders have specific insurance requirements for approving loans within HOAs, and those kind of sources, those serve as an indirect regulatory entity in terms of what these HOAs are buying and what coverages they maintain. So let's talk about what's required under the statute. So the Davis-Sterling Act that Diane mentioned, there are 3 sections of the act. There's 2 on this slide and 1 on the following slide that talk about insurance and have specific requirements for community associations subject to the act. These first two deal with liability insurance minimums. And these 2 are a little different from the third one in that they're not a legal mandate that associations require these minimum limits. They're quid pro quo. If associations maintain these minimum limits, in exchange, their members and or directors are privy to certain protections. So there are statutory protections that associations can benefit from if they maintain these minimum limits. So 5800 is about limitation of liability for volunteers. This is kind of the D&O minimums. As long as an association maintains $500,000 of D&O protection, D&O insurance, which is directors and officers liability coverage. We'll talk about what that involves a little bit later. But the directors and officers coverage, that liability insurance, that's coverage for if the board makes a mistake or is accused of having made a mistake in their governance and administration of the project. So it's like their medical malpractice insurance, their professional liability coverage, their errors and omissions insurance. If they maintain a minimum of $500,000, if the association has 100 or fewer units, that is sufficient to afford the individual board members specific statutory protections as enumerated in this section. If the association is more than 100 units, they have to maintain a full $1 million in D&O limits. Most associations, it's extremely rare for an association to only have $500,000 in D&O protection, regardless of size. Typically, you're going to see $1 million. Sometimes you're going to see much higher, depending on how large the project is. Maybe even the values within the project. There can be a perception that where It's a more affluent community. The owners, the units cost more. There might be more legal activity in some of those associations than in smaller ones or ones where the values are lower. So that's the D&O minimums. The general liability minimums are in section 5805. And this says if you have 100 units or fewer, you must maintain a minimum of $2 million in liability insurance protection as an HOA in order for your members to be shielded from personal liability. This means that if someone slips and falls in the common area, sues the association, they may not sue each member of the association personally, pierce that corporate veil, so to speak. They're prohibited from doing that if the association maintains these minimum limits in general liability insurance. So $2 million if you're 100 units or fewer, $3 million per occurrence if the association has more than 100 units. So those are our first two statutory requirements. This third one is a little bit different because this one is not, if you do this, you'll benefit in this way. So it's somewhat optional. This one is a legal mandate. All associations in California must maintain fidelity insurance, sometimes called crime insurance. We'll talk about what fidelity crime coverage is and does a little bit later. But this just says basically there were some major issues in California with embezzlements and thefts in community association where the HOA's funds were evaporating due to dishonesty. And the legislature was made aware of the situation and they decided we really need associations to maintain a minimum amount of fidelity insurance to protect the members because this can happen. It's unfortunate and you never expect that it will happen, but it can and does happen. So those funds need to be protected via insurance. And we'll talk about that a little bit more later, but there's a specific formula with the minimum amount of coverage that is required. And it's basically how much money could someone make off with at one time? And the rough formula that they've come up with is about 3 months worth of operating assessments plus reserves. That's the amount that somebody, if they decided on a given day to clean out your bank accounts, that's probably the approximate maximum that they could make off with. So that's the amount that the legislature has prescribed as the minimum limit for fidelity insurance. They've also said it's not enough just to include employee dishonesty or theft by an employee, a volunteer, board or committee member, or a managing agent. You also need to include computer fraud and funds transfer fraud. These are crimes that could happen anywhere in the world. And as realtors, you guys, you know a lot about funds transfer fraud, given your disclosures that you have to present during those transactions, right? You're always, I closed escrow about a year ago, and you know there are multiple those single pages that please call, verify the transfer instructions carefully. So I know you guys are all familiar with how big of a problem this has become and the necessity of educating people on it. So that insurance for that exposure, if someone does get misled and there is a funds transfer fraud or a computer fraud, the association needs coverage for those crimes as well. So the policy is required to offer those insuring agreements. And then coverage for a managing agent, if applicable, if there's a professional community manager involved. The crime policy for the association must extend to dishonest acts committed by a management company employee. So those are the requirements set forth under the statute. Then we've got CC&Rs and bylaws. It's common for CC&Rs or bylaws to include an insurance article, and that's the first place you'd want to look for what the HOA is required to insure. Because the ownership interest, the legal form of ownership that Diane was talking about, whether it's condominium, planned development, or a cooperative or community apartment project, those legal forms of ownership do not necessarily dictate what the HOA is required to insure. Those can vary even within these various ownership types. You can have planned development, for example, that is required to cover the residences, the actual structures. It's not common, but it can happen. So the governing documents are one of the first places that we look to see what is this association, what is this entity required to insure. And the insurance article can be very helpful for that. Again, there are older sets of governing documents that might not have the insurance article, so we might need to look elsewhere. And that's where we might consult the maintenance and repair obligations, which are always in there somewhere. Ideally, as Diane mentioned, there will be a maintenance matrix somewhere. If there isn't one of those, the maintenance and repair obligations will still be set forth somewhere in the governing documents. That will always be present, whether there is insurance language or not. So that would be our backup. If we can't find specific insurance dictates, then we're going to look at the maintenance and repair obligations and make sure that at a minimum, the association is insuring what it is required to maintain, repair, and replace. It's possible that the association's actual insurance could be broader than that, but certainly at a minimum, we would want to meet those maintenance and repair obligations. If there are specific insurance obligations, then at a minimum, we want to meet those. So the takeaways from this slide, the legal form of ownership does not necessarily determine the insurance requirements for the association. You really need to look at the governing documents and find the insurance language if it's in there, or the maintenance and repair language as a backup. So insurance required by lenders. Why do lenders care? What difference does it make to lenders what the association maintains in terms of insurance? The lender isn't lending to the HOA entity. They're typically not lending to the corporation. They might be. HOAs certainly do get loans, and there are certainly insurance requirements for lending transactions in that respect. But from day to day, lenders always want to know what coverage the HOA maintains. Why is that? Well, there's the obvious answer, of course, is they want to know that their collateral is protected. But then there is the less obvious answer that they want to know that their borrower is on an ongoing basis going to be able to pay their mortgage. And if the association doesn't maintain proper coverage, it increases the chances of special assessments, and those could impair a borrower's ability to make timely mortgage payments. So lenders are protective of this, and that's part of what they're looking for when they start going after some of these more stringent lending requirements, when they want to see the fidelity bond and be assured that it is, meeting that civil code formula. It's because they want to know that if someone steals from the association, there's coverage in place to restore those funds to the HOA without the need for a special assessment, which could impose a hardship on their borrower and make them unable to pay their mortgage. So those are, as I perceive them, the reasons why the lenders care so much. And these requirements from lenders, from the FHA, from Fannie Mae, Freddie Mac, they have become increasingly detailed over the last 5 to 10 years, as I'm sure you all are familiar with. They're starting to ask for more and more and more on those certificates of insurance. They want to see special form language, replacement cost language. They want to know about co-insurance and inflation guard and severability of interest. So many, there's a long, long list. So because lenders are requiring these provisions, again, it's an indirect regulation on the coverage that HOAs are quasi-required to maintain to make sure that owners in their project can buy and sell without undue hardship. I have the National Flood Insurance Program on here because, as some of you know, I'm sure, as soon as a property gets designated to be in a special flood hazard area, one beginning with A or V, lenders, whether they are FHA, for Fannie Mae, Freddie Mac, regardless, lenders across the board are going to require flood insurance. And this can be very difficult for community associations, specifically condo projects, because I just had a situation a month ago where an association in Venice was reclassified into flood zone AE. So they came into the 100-year floodplain, which does not mean that you're only going to have one flood every 100 years. It means that in any given year, you have a 1% or higher chance of flooding. So the math works out that through the life of a 30-year mortgage, you have a 26% chance of flooding, which lenders see as this needs to be addressed by insurance. So since these are condos, the individual owners don't have the ability to insure their four walls, correct? The HOA has to purchase what's called an RCBAP, a residential condo building association policy. It just rolls off the tongue, doesn't it? However, you might have a 6-unit building and only one of the lenders in that building is really requiring this RCBAP. They are refusing to allow their borrower to purchase personal flood insurance. There's a sale pending. They want to see the condo building fully covered by flood insurance before they will allow the sale to close. This was the situation that we had. So in that, the HOA did not have the funds to purchase, and this was a 10 building project. They certainly didn't have the funds to purchase coverage for all 10 buildings, and they couldn't justify purchasing coverage for just one building for a single sale. So the seller actually paid $8,000 for the RCBAP policy to cover the whole building just so this sale could close. So you may encounter that situation from time to time where it seems unreasonable, but I will tell you that new loans are much more difficult than existing mortgages. If a flood zone gets redesignated in the middle of an existing mortgage, it's much less likely that that lenders would require such a drastic purchase as that situation, but that was the situation that we dealt with recently. So lenders are very, very concerned about flood insurance and insurance in general because they want that collateral protected. There are two main types of coverage that we deal with for HOAs, and that's property insurance and liability insurance. Life and health insurance, I don't know anything about, so that's completely separate from what I do. This is property and liability insurance, sometimes called property and casualty insurance. So property coverage, these are your first party damages. Financial loss to the named insured. I am my own first party. If my property is damaged, that's what we're talking about here. I need to be reimbursed for my loss. It's my loss. So that's what we mean by first party. Typically, in order for a loss to be covered, it needs to be a fortuitous loss. This is an insurance word that just means sudden and unforeseen. Maintenance losses are not insurable. If your roof is leaking because it is old and needs to be repaired or maintained, you can file an insurance claim for that, but it will likely be denied because it's not a sudden and unforeseen loss. And if insurance covered maintenance, no one would actively maintain their property, right? They would submit claims and allow the insurance company to pay for that maintenance. And the result would be that insurance costs would rise and rise and rise until they were prohibitive. So many of the exclusions that you see in these policies are intended to keep insurance reasonably affordable so that it's there for those sudden and unforeseen, difficult to calculate, difficult to predict losses. Most recently, in the context of the pandemic, one of the major reasons that pandemic coverage is not widely available via insurance is because it's a huge loss sustained by a giant population all at the same time. It would cause the companies to go bankrupt if it was covered. And if they didn't, they would have to charge so much for that coverage that none of us would be able to afford any insurance. So that's the thinking behind some of these exclusions. Some of them are a matter of public policy, and some of them are simply intended to keep insurance cordoned off for those sudden, unforeseen, occasional type risks that you can't always calculate for. Liability insurance is our second big category here, and this includes third-party injuries and damage. Slip and falls are one of the most common examples. Property damage, if the association fails to maintain some component and it results in damage to someone, to a unit owner's interior, for example, then that might be a liability loss for the association, especially if they had reason to believe that the component was at risk. So for instance, a tree limb falls on a car. If there was no reason for the association to be aware of the health of the tree needing attention, that might just need to be covered by the vehicle owner by their comprehensive coverage under their auto policy. It was just a sudden and accidental type thing, and the vehicle owner would be responsible. However, if the homeowner that lives in front of that tree had told the board, hey, I'm worried about this tree. It looks, it's swaying a lot in the wind, and I'm concerned that, some of the branches aren't looking very healthy, and the board does nothing, and then the tree limb falls on that same car. That would be a liability situation where, yes, it's discoverable that the board had reason to know the condition of the tree. They took no action. A third party's property was damaged. Now the association is responsible for that damage and for paying that claim. This can also include hurt feelings, invasion of privacy, character assassination. Those types of claims are included in the context of liability insurance. There is a need to prove negligence, as I was just describing with the tree limb vehicle scenario. You need to show that some standard of care was not made good upon. There was some failure that, to borrow Diane's words again, a reasonably prudent person should have done things differently. So the main types of property insurance that we see in the context of HOAs are what we call special forms. Sometimes we call this master insurance or fire insurance. It does cover fire, but it covers so much more. A special form policy covers everything that is not excluded under the policy language. So direct physical damage to the property that is not excluded in the language is covered. So this is going to include things like fire, wind, hail, riot, civil commotion, vandalism, malicious mischief, aircraft, theft. These types of claims are certainly all going to be covered by this policy. The big exclusions there are a number of exclusions in the policy, but obviously it's an open form, so there's many more things that are covered than are excluded, but the big exclusions are earthquake and flood. As these are catastrophe perils, they need to be underwritten and priced separately, particularly in California. Flood across the country, flood has to be written separately. It's not typically in commercial insurance able to be rolled into the master policy. Fidelity crime, since money is property, a fidelity policy is a property insurance policy, and we'll talk more about these later. Okay, we're going to spend a little bit of time here because I know there's a lot of confusion on walls in coverage, what it means, why it's, why it is the way it is and when. And lenders always want to know, is there walls in? Is there walls in? The first thing I want to say about walls in coverage is that walls in is not an insurance term. I will tell you that I've been specializing in community association insurance for 15 years. I have never seen the words walls in a policy. So that is much like townhouse. Diane was talking about how a townhouse association is not actually a legal form of ownership. It's a term used in other industries that we kind of bandy about. Walls in is a term that lenders and realtors and homeowners have started to use, but it's not actually a contractual term in insurance policies. So we call these insuring agreements, and there are 4 possible, and this is specific to condos for the most part. When you're looking at that airspace ownership and you've got those interior fixtures that are a permanent part of the real estate, but everything from the unfinished surface of the drywall inwards is legally owned by the unit owner, but the association may exercise some degree of insurance over that property. So there are 4 different types of insuring agreements with respect to those interior permanently installed features, fixtures, finishes, and appliances. The first one is the most confusing. The first one simply defers to the CC&Rs. It says, whatever the HOA is required to insure is covered. No more, no less. So what could go wrong? Unfortunately, not all CC&Rs, particularly older documents, but even some newer ones, not all of them are crystal clear in terms of what the association is required to insure with respect to those interior fixtures and improvements. So what happens then? Then you have a claims adjuster after the loss happened trying to interpret what the governing documents call for. They may need to get their legal team involved. Their legal team may have a different opinion than the association's attorney. So a lot can go wrong with that style of coverage. I would say about 10 years ago, most policies had that language that pointed to this outside document that the carrier may have never seen. And that has become much less common over the last 10 years, particularly as lenders have required greater clarification on this issue. The insurance market has responded and started to more commonly issue these affirmative endorsements that clearly state what is covered instead of pointing to some offsite document that may or may not be clear. So that's the first type, the most problematic, certainly. If the documents are clear, though, I will say this option allows for the greatest customization in the association's insurance, because it's the intent of it was always so that the association's insurance would naturally comply with what the documents required. So there are pros and cons to that first option, but bare walls, this is the one where the HOA insures up to and including that unfinished drywall, but nothing more. Everything the unit owner legally owns inside that airspace, they are responsible to insure on their own. So some associations have that bare walls coverage, and it's important to find out what the HOA does maintain. The most important thing for your clients to know, regardless of what's required by whom, they need to know what the HOA actually maintains and how they can supplement that protection themselves. So that's the most important question for them, not what the HOA should maintain, not what's required to maintain. For your client, they need to know what the HOA does maintain and what that means for them. So that's the big takeaway for your customers as you're working with them on their sale and purchase transactions. So single entity is the third type. This is when the policy covers those interior fixtures and improvements up to the level that they were originally installed. Now, this doesn't mean that if there was lime green carpet and Corian countertops and linoleum in the laundry room, it doesn't mean that you have to rebuild that way. It just means that the carrier is going to adjust the claim and pay for finishes that are on that level, that are of that kind and quality. Today's standards, obviously, today's materials and today's dollars, but they're not going to pay for upgrades that may have been installed over time by the current owner and all previous owners of the unit. So that is sometimes called walls in, excluding upgrades. All included is, of course, the broadest policy form, and this is everything that wouldn't fall out if you were to turn the building upside down and shake it. The HOA is covering all included. Sometimes it's called all in, but that's all of those permanently installed features inside the unit are covered. Regardless of which insuring agreement is at play, it's going to be subject to the association's deductible and to their policy limits. And this is really important because some unit owners buy a condo and they think, oh, the HOA has all-in coverage. I don't need any insurance. Well, what if the HOA has a $10,000 deductible? Do you want to be out of pocket for the first $10,000 if the loss happens inside your unit? Deductibles are not typically prescribed by governing documents. The HOA can maintain, in most cases, whatever deductible it wants. That's not true in every circumstance, but it's often true. So it's really important to look at that deductible, look at those policy limits. There could be a shortfall. There could be a total loss that costs more to rebuild than the policy limits. Hopefully not, but it is possible. So every unit owner should maintain some amount of insurance. For condos, this is called an HO6. So let's talk about, there are two homeowners policies that are going to be really important for your clients, depending on the type of unit that they're purchasing. If it's a condo, they need an HO6 in most cases. If it's a single family home, they need what's called an HO3. And these policies have 4 to 5 coverages that are really critically important to the unit owner and only cover what the unit owner is personally responsible for, which the HOA cannot cover because it doesn't have an insurable interest. The The building property, at a minimum, you want this coverage equal to the HOA's deductible. You might want more if it needs to cover improvements beyond the original builder specs, or if the association has bare walls, they might need to cover every permanently installed feature inside that airspace. Personal property, anything you can pick up and move around the unit, is always the homeowner's responsibility to insure. Personal liability, someone slips and falls inside your home, that is not covered by the HOA. If your dog bites someone in the common area, that is not covered by the HOA. That is not related to the ownership, maintenance, and repair of the premises, which is what the HOA's liability insurance covers. Loss of use, if the unit burns down and you need to live somewhere else while it's being rebuilt and you incur additional living expenses on top of your mortgage, which doesn't go away after a fire, because you've still borrowed that money. Additional living expenses is also called loss of use. That can also be loss of rents if you have a tenant in the home. So loss assessment coverage, this is specific situations where maybe the big example right now is some associations in wildfire prone areas have extremely high wildfire deductibles, 1 million, 2 million per occurrence for wildfire, because it's so difficult to get insurance in those areas right now. Loss assessment is extremely important, because if there's a loss and the board special assesses to fund that wildfire deductible, the homeowner can submit that special assessment to their HO6 carrier, and that would be a loss assessment loss. So all of these are important coverages. Personal insurance agents can advise regarding specific limits. The HOA's agent or broker can talk with them about what the HOA maintains and answer questions. I have comprehensive auto coverage on here because the HOA is not going to cover damage to an owner's vehicle unless they were negligent in the damage. We're a little tight on time. Scott, do you want me to?
Yeah, go ahead.
Okay, I'll be quick. Fidelity crime coverage, we talked about a little bit. This is coverage for the association's money if someone embezzles. So there is, for a long time, this was called employee theft or employee dishonesty coverage. Employee theft is one of about 9 coverages within a crime policy. We call them insuring agreements within this crime policy. So the employee theft piece is important. In an HOA crime policies, if they're well written, they define employee as not only including payroll staff, but also including non-compensated directors and officers, volunteer committee members, and other volunteers working at the board's direction that might be performing duties within the scope of what an employee would be doing. Also, many HOA crime policies extend the definition of employee even further to include community managers and management staff. So if a manager embezzles from the HOA, that dishonest act would be covered under the employee theft insuring agreement. As I said, there are about 8 other insuring agreements that are coverages determined not based on the person who perpetrated the act, but based on the crime that was committed. So for example, forgery or alteration. If a payee forges or alters an association check so that it's $1,100 instead of $100, that could be covered under a crime policy if you have purchased a limit under the forgery and alteration insuring agreement. The 2 big ones are computer fraud and funds transfer fraud that we talked about earlier. Those are required by the civil code, and those can be perpetrated by anyone, anywhere in the world. So that's why they're separate from that employee theft piece. Social engineering deception fraud is a new coverage under fidelity policies, and this is if an employee, board member, or manager gets tricked into voluntarily giving money away. Someone masquerades as a legitimate payee, as a vendor, or as another board member, for example, and they fool someone into giving them money. Well, typically, a crime policy wouldn't insure you for giving money away. So it's important to have this extension on those policies. As we talked about earlier, there are limit requirements via the Davis-Sterling Act. CC&Rs sometimes prescribe a required limit for fidelity insurance, and then lenders are getting stricter about requiring typically the same limit that we see in the Davis-Sterling Act. We're not going to spend a ton of time on liability insurance. These are the various types. Some of them you're probably more familiar with than others, but the two that are addressed in the Civil Code again are general liability. This is if a third party sustains bodily injury or property damage on the premises and the association is deemed negligent and at fault for that injury and needs to pay damages. Personal or advertising injury, these are things, again, like wrongful eviction or invasion of privacy or malicious prosecution, things that amount to hurt feelings is what we call personal injury in the insurance world. I know in the legal world, personal injury typically refers to bodily injury, or what we call bodily injury. Advertising injury, these are things like copyright infringement. So we'll skip down to directors and officers liability. Again, I think I have a slide for D&O. This is wrongful acts, claims against the association or the board or both that say you made a mistake, you made a bad decision, you did something wrong, you breached your fiduciary duty. Coverage can differ so much from one D&O policy to the next. So it's really important to know that these are not all created equal. The general rule of thumb is that if you buy a super cheap D&O endorsement in your master policy, it probably isn't covering all that much. This is a claims made coverage, which means it doesn't matter when the alleged wrongful act occurred. When the claim is brought to the association, the policy that's in force when the claim is made is the one that responds. So that's a little bit about D&O insurance. Additional insured requirements, I want to just very briefly, there's a question that comes up pretty frequently about our community manager wants to be additional insured on our general liability and D&O policies. Is that reasonable? And the answer is yes. Every management contract that I've ever seen does include that language. It does say that the manager must be additionally insured on those policies when they are acting at the board's direction. So that's the critical caveat there. So if a manager is carrying out the instructions from the board, which is typically what they're doing, then someone disagrees with the board's decision, their attorney is very likely going to name not just the board, but the management company in their suit against the association. They'll name the association as well, of course. So in those situations, the management company should be entitled to be defended, have their defense paid, and any settlement or judgment paid by the association's coverage, since it was the board's decision and the manager was only acting at their direction. This does not extend to rogue acts of the manager. So if the manager goes off and does their own thing, they need their own errors and omissions coverage for that. That's not what we're talking about here. We see a lot of requests for the manager to be additionally insured under the fidelity crime coverage. It's not exactly precise language to call it additional insured. What they're really looking for is that definition of employee extending to managers and management staff, so that a dishonest act of a manager will be covered under the fidelity crime policy, but they're not additional insured. They're not entitled to receive payment from that fidelity crime policy. Okay, I'm not going to talk about workers' compensation. I don't feel it's very critical to this discussion. I will only say HOAs should maintain it even if they have no employees, because employment law can surprise you. So that's why many HOAs, even without staff, do carry this coverage.
And we're good. All right, well, thank you very much. Appreciate that. We're going to talk about finance and roll right into reserves. If you have any questions, go ahead and type them in and we'll get to them as soon as we can. Some documents that are required in the Civil Code as it relates to HOA finances include a balance sheet, an income and expense report, a check register, a general ledger detail, and a reconciliation report, which is what you had planned versus what the actuals are. These are all reports that are required to be distributed to the membership per the Civil Code and available upon request within 10 days. I can tell you that if you're looking for what's the issue here, look at your delinquency report. You can have a member, so if you're taking a listing in a property, have your member pull up the delinquency report. If the delinquency report is high, that means you're probably over the 15% threshold for most lenders, in which case you're going to have a difficult time getting financing on a unit in there. If it's low, then you'll generally be okay. But those are the little piece of information that you can pull from these kinds of reports. Also, the prepaid report, whether it's zero or not, you can prepay your assessments. And this happens a lot, particularly in associations with small assessments, like $50 a year or something like that. They can pay a year in advance or multiple years in advance, and the HOA is required to accept these monies and note them in a prepaid report. It's unlikely, but in the situation where you have a lot of prepaid reports, you want to look at the finances and the cash flow of the association, because they may not have as much money coming in the future because of these prepaids. You need to understand the budgets. The board has to look and understand what the goals and the needs of the community are. So whether it's trash pickup 2 or 3 times a week, whatever their utility bills are, et cetera, those are the bills that need to be paid. And then you would have some goals on top of that. Maybe you want to have a giant 4th of July barbecue to promote community unity or something like that. Those are all policies and procedures that the board needs to consider when determining their assessments for that particular year. Associations work in fiscal years. Most of them are 12/31 to 1/1 to 12/31 years, but they vary. So you can go 6/1 to 5/31 or any other, but they're always 12 months in a fiscal year for an association. The anticipated income for each of those and the anticipated expenses are supposed to be outlined in those. And then the civil code doesn't have a lot in its detail. However, all operating budgets are to have a reserve fund allocation. So maybe you do or don't have trash pickup. Maybe you do or don't have janitorial. So those will vary by association. But all associations need to set monies aside into the reserve fund. And thus all operating budgets are required to have a reserve fund allocation, whatever that number may be. Estimated revenue and expenses on an accrual basis. That means as a kind of a monthly versus cash flow. Cash flow is like your checkbook. So you get money in, it goes up, money comes out, it goes down. Whereas on an accrual basis, it shows. So on the 1st of the month, you're due all of the monies. They may not come in on the 1st, may straggle in over the next few days, but you're entitled to all of that money on the 1st. So you book it. By the same token, you're going to have to pay all of your bills. You may not pay them on the 1st, but they are accrued. So that's just a simpler way to look at financing and understand it versus a cash flow method. And of course, the reserve funding has to be included, as we've talked about. Budget increases, the board has limitations. The regular assessment increases are up to 20% without membership approval. So the membership can assess themselves whatever they want. So if the membership approves it, there is no limit. If the board is acting on its own, they limit it to 20% of whatever the current assessments are. They also have a special assessment, which is kind of funny because a lot of years I've heard a lot of people paying these monies, never anybody call it that special, mostly a surprise assessment. But nonetheless, it's 5% of the budgeted gross expenses, which is typically not a tremendous amount, but it can add up, particularly for those associations that have large assessments. So those are the limitations that associations have to work under, with the exception of an emergency special assessment. If there is a threatening to life or limb, then the board does not have those limitations and they can assess the membership whatever is necessary in order to make these improvements. So hypothetically, if you have a deck that's ready to fail and collapse, the association can assess whatever is necessary to the individual memberships to correct that situation. They are allowed to borrow from the reserves. It says that you will not expel any funds for the use of anything other than the repair, restoration, or maintenance of these items. However, if you need the monies for other items, you can borrow from your reserve fund, and then you need to pay it back within 12 months. Some annual reports, you have an annual policy statement, and it's both policies. So whether it be an insurance policy, or whether it be a policy on parking. So all of the policies in place have to be distributed on an annual basis as part of what we call the annual budget report. That has to be done 30 to 90 days before the beginning of the fiscal year. And then you have the year-end financial report, and as the name would imply, it's after the year. So the annual policy statement has to be sent out beforehand, and it's a pro forma operating budget. So it lists what the anticipated expenditures are. Of course, it's going to change throughout the year, but this gives an estimation and what your assessments are going to be based on. They also have to disclose a lot of financial information, including that pro forma operating budget, all your reserve plans, reserve funding plans, assessment reserve funding disclosure summary, all of that, which we'll be covering in our next section. Now, they can either distribute the full copy or a summary report. Most of these laws were written long before PDF. So a lot of times they wanted to save trees and not have to print all this information out. So they allowed for summaries. Now, most of them are put into PDF and just sent out as whole reports. Some of them are in summary form. So if you do get a summary and you want the entire report, you can just simply ask for it as a member. There are some consequences for failure to distribute timely. The one and only penalty listed in the civil code is in this section. If a board of directors fails to give this information, meaning that they don't meet that timeline, they don't give their pro forma operating budget, they lose their authority to increase their assessments. Yeah, I'm going to repeat that. If they have not given you a pro forma operating budget ahead of the fiscal year, that 30 to 90 days that you see up there at the top, the board is now prohibited from increasing the assessments for that fiscal year without membership approval. So for all of you that have not received your information and your board has increased your assessments, oopsie doopsie. The year-end financial report, it's within 120 days of the end of the fiscal year. So that generally means by the spring or summer. If your gross income exceeds $75,000, then you're going to have either a review by a licensed certified public accountant, or many CC&Rs require that you have a formal audit. The civil code only requires the review above the $75,000 figure. However, many associations in their governing documents and as a matter of practice do get full audits each and every year, which of course is a good idea. Maintenance. This will be a short section. So of course, the association has an opportunity, a responsibility to maintain the association common elements. And they do this two ways, either in the operating budget or the reserves. So the operating expenses, as you imagine, the routine stuff that is on a regular basis, and the reserve is the replacement of things that are much less frequent. The importance of this is to make sure that you have contracts with all these providers and that these contracts get reviewed by in-house counsel, because many of these contain terms that may be detrimental to the association. So your ongoing contracts, your maintenance, those are usually reviewed and part of the process. However, every time you replace a roof or a water heater or another component, you're typically going to engage in a contract, and you'll want to have that reviewed by your attorney, which is a good reason to have your contractors be routine so that you don't have to review a new contract every single time that you want to install a new component. Some fiduciary duties you can see outlined as the Bismuth judgment rule that we've talked about previously. If you are interested, you could look at the Corporations Code 7231, which outlines the officer's directions, whether it be a nonprofit or a regular for-profit corporation. And then, of course, the consequences for failure to maintain can be significant liability. We've talked about that, business judgment rule, et cetera. And my estimation would be that if you let your property run into disrepair, you may not have much legal protection. All right, reserves, we're moving now. By the way, the most important document, I know others will disagree. So my reserve study is made up of two parts. You've got the physical analysis, which is what's there present at the property and their condition. And then the physical analysis, what kind of revenue streams do we have? What kind of expenses do we have? And of course, our beginning cash balances. So the component inventory lists all of the items the association is responsible to maintain, and that'll stay relatively stable from year to year. The condition assessment will change from year to year. Properties, they get older, so the items in them get older, and then of course items get replaced, and then you have to reassess and change that. So from year to year, you'll have that condition assessment adjusted. And then the life and evaluations will also change year from year. Most of them are generally inflationary adjustments upward. However, there can be some volatile components often tied to commodities. So for instance, asphalt, very tied to the cost of crude oil. So when the cost of crude oil expands, well, then the cost of asphalt goes up. When it drops, it drops. So those will change from year to year. So if you have a 2, 3, 4, 5-year-old estimate on that, it's probably irrelevant by this point in time because you had such a change to the underlying estimates, which is why you want to do a new evaluation with each reserve study update. The financial analysis, a finding of the current fiscal status. And we're going to show you the calculation on that, but it's a percent funded. Where are we at now? Which gives you kind of an idea where you are on general terms. And then a funding plan, and this is the most important, are recommended for an appropriate reserve contribution rate. Remember, we talked earlier that all associations have to have in their operating budget how much they're setting aside into reserves. Well, how much is that? Well, the reserve study is going to give you the recommended amount. The association is not required to follow that. They should probably have a good reason for not following the advice of the professional, but they are not required to follow that advice. It's just a recommendation, and they can choose whatever contribution rate they so desire. So essentially, it's what is the association responsible for? How much of it is there? What are their conditions? How long is all this stuff supposed to last? How much is it going to be cost? Where are we at currently in our situation? And then the most important, how do we pay for all these items in the long range? There are 3 types of services. Typically, you've got the full study, and as the name would imply, it includes everything. So they go on site, they identify the components, they quantify them, do the evaluation, and all the life evaluations and cost estimations. An update without site visit should only be done after you've had the full study, but after you've had your full study, then you've got your component inventory and you don't have to re-quantify those components again. So they just validate that those components are there, and then they update the condition assessment, life evaluations, and the funding scenarios. Also, they have an update without site visit. It's often called a desk consult. You don't visit the property, you just simply take in new information. So you update the beginning balance, the contribution rate, the assessments to the liabilities, and you produce a new funding plan that the board can adopt and distribute to its membership. The frequency of these, a visual inspection is required at least once every 3 years. So after you have your initial, that qualifies as a site visit, and then every 3 years you would update that site visit. They have to review the study annually, and they have to provide a funding plan to the membership each and every year, which has to be adopted at an open meeting. Here's your favorite form, and if you didn't know that, well, now you do. This was created by the real estate lobby many years ago, because what was happening, if you remember, go back to the early 2000s, there was not a lot of discretion in the lending world and in the purchasing world. I believe at that time, the requirements to qualify for a home loan were the ability to cast a shadow and fog a mirror, and only one of those was really required. So there was not a lot of discretion on the lending institutions about who was going to borrow this money, and subsequently there was not a lot of discretion on the borrowers on the entity they were about to purchase in. So what would happen is people would purchase into these HOAs, and then sometime after that, they would get notified of these, we call them special assessments, but often they're a surprise. And so what would happen is they would typically take their real estate professional to small claims court looking to get back these monies. As you may know, there's a high percentage of winning in the small claims arena for consumers. I believe it's upward of 70%. So a lot of realtors were getting what we'd call nickel and dime, and would suffer what we call in the industry a commission-ectomy, the removal of a commission. So they didn't like this, as you can imagine. So they created this form. And now with this form, of course, the consumer has a lot of information to make an informed purchase decision. The other aspect is now it is virtually impossible to sue a real estate professional for the financial condition of an HOA because you were told. So if you look at this, item number 1, the regular current assessment is X, and so much of that is going to the reserve. So very clear on where the money's coming in and where it's going. Item number 2, are the regular assessments been approved? Okay, are there any special assessments? Well, yes, as a matter of fact, this one has been approved and it's $780. Okay. Number 3, if we follow all the guidelines outlined in the funding plan, are we going to have enough money over the next 30 years? Yes or no? Well, obviously, if you say no, that may be problematic. And if you say yes, they say, okay, we're on a good track. Now, if the answer is no, well, we're just going to run down to number 4. If that answer is no, then you have to tell us specifically when and where these special assessments are going to show up over the next 30 years and the amounts. Wow, that's pretty detailed. Number 5, it's not really, all major components are included in the reserve study and its calculations. Now, the reason that is in there is if a reserve study preparer does a terrible job and they omit some items to the reserve study and it changes these numbers, well, then who are we going to look to? Do we want to look to the reserve specialist? Yeah, that's who we're going to want to look at, the person that prepared the report, and that puts it in plain English. And then you see 6 and 7 are just outlining. The Civil Code allows a term it's called full funding, and we're going to talk about that in a second. Now, you are not required to adopt full funding. So in this scenario here, you're required to show what full funding looks like and then what you've adopted. Sometimes they mirror themselves if you have adopted full funding. If they have not, then it will not. So it's to show the membership what full funding looks like, and then of course what the association has adopted should it be different. And like I say, this form is required to be attached to all fiscal year's financials. So every single year you should have this form attached. And then the other disclosure that's very important, of course, is the funding plan. And as you can see, this information is very detailed. So the assessments right up there at top, tell us how much we're going to collect as an association in our assessments. Then our special assessments, are any of them done? Good news here. No, there's not any special assessments outlined in this particular funding plan. Interest income, you have money now and you're going to earn money on your money. So we want to calculate that into the funding. And the component costs, we know that every year we buy some. Some years it's very little, some years it's a lot. It will vary greatly, but we're always going to be spending money. So we want to calculate that into the process. Then we have our net dispersed. So some years we spend more money than we bring in. Other years we bring in more than we spend. And this simply shows you that calculation. We want to know the cash balance at the beginning of the year. And then of course, at the end of the year. And then our liability, that's the built up or accrued depreciation that we're going to talk about in a second, less our beginning balance, because we have that depreciation, right, but we also have some money. So it takes us out to that this particular point in time, this particular association is $766,000 underfunded. Okay, well, what does that mean to me as an owner of one of 58 units? Well, you can keep your calculator in your pocket because that divisible number is 13,209. So if you want to know where this particular association is on an individual basis, each member is technically upside down by $13,209 in deferred savings for the items that have aged. And as you can see, it changes from every year. In this scenario, they start off at the $13,000 and they bring it all the way down to $125 in 2032. And then the third required disclosure, I know it gets repetitive after a while, but they require these disclosures every year, is just the basic summary. And it has, as you would apply, basic information. So at the top, we see assumptions. All right, well, this is just the fiscal year that we're talking about. The inflation factor. So again, items increase over time. We want to be able to capture that and apply them to future costs. So we do that there. The money that you're making on the money, we want to put that into the calculation. You have money now, so we have to calculate that. And then the divisible number. How many units are there? And that's 58. This middle portion here is the reserve contribution just by itself. So the amount budgeted, currently the association says we're putting away $5,850, which equates to $100 per unit. All right. The recommendation of the reserve analyst based on their information is that they increase this to $8,300 or $143.63 per unit. Again, keep your calculators in your pocket. That's $42.77. So the recommendation is that these particular folks increase their assessments by $42.77 and put that all into the reserve fund, which is an increase of 42%. Good news, as we've talked about, no special assessments recommended for this particular association. And then you see item K is, well, how much more are they going to have to go up? And you see in 2018, 2019 year, it's going to go up that 42%, and that's the end of it. And we'll show you that diagram in a second. And then the bottom is the total. So this includes all the assessment amounts. So the amount budgeted currently is $521.48. The amount they're currently putting to reserves is 19.34%. And these are important numbers that we'll talk about in a second. So in order to facilitate the recommendation of this particular analyst, you're going to have to increase that regular assessment, that $521, by 8.2%, which equates to that $42.77. So that's the recommendation. Again, the board can make the decision to follow that recommendation or do something entirely different. And then you see down below that, it's the overage or deficit, that same number that we spoke about in just a moment ago, $766,000, $13,000 per unit. This number was put in there by the real estate lobby many years ago. For those of you that know Gov Hutchinson, next time you see him, give him a big hug. I guess ask first, but give him a big hug because he was responsible for this. Now, the idea is we want to know what's going on in this particular transaction, and we don't want to slow it down. So the idea here is to give them a scope of activity. So in this scenario, we see that the association is underwater by $766,000, $13,209 to meet. So that's the number that's known. And now the real estate agent could go about doing their work. Now, I can tell you in a soft market where you maybe have a divorced couple been there for 30 years, lots of equity, you might get some movement on that $13,000. Yeah, it's quite possible. Now, I can tell you in a more difficult market, somebody who's been in the property for a little bit of time, has no equity, and is trying to get out of town before the bankruptcy court gets them, well, you're probably not going to get any movement at all on that $13,000. The important point is that both parties know about that $13,000. It's negotiated as part of the process. And so after the fact, nobody can claim I didn't know. So it puts everything in full disclosure. It's complete transparency. And that's quite frankly what the real estate lobby has been working with for years, is to provide complete financial transparency to potential purchasers. And they do that through the reserve study and these forms that we're working through. Despite our best efforts, not all associations are required to have a reserve study. I'll work on that in Sacramento, but some exceptions to that are if you don't have a common area, you're not required to have them. And of course, those that don't have a commercial, those that are residential only and are, do not have a commercial operation. So commercial properties are exempt. They have their own section of the civil code. Residentials are included so long as they have common area and their assessments are equal to 50%. So if half your assessments, if half your assets are up to your operating budget, you're exempt. But that would only include a small, like PUD. All right, the calculation method. We always get this. So the calculation method outlined in the Civil Code is as follows. So we see our line item here. We've got a roof. It lasts 15 years. We've got 5 years left. The replacement cost is $20,000. So we have an annual cost to every component, and it's going to vary because some things cost, of course, different, and they last different times. But that number comes from simply dividing that $20,000 by the 15 years, which equates to $1,333 per year in annual cost. Now, currently, since it's 10 years old, you would multiply that 10 by the 1333. So your percent funded at 100 would be 1333. So if you do in fact have that, you are 100% funded. Same calculation on the water heater. This is 10 and 5 and $1,000. So the annual depreciation is $100. And at this point in time, the accumulated depreciation is $500. So this association in this scenario, at this point in time, if they have the $13,833, they are 100% fully funded. They don't need the full $21,000, the total cost of their assets, because they're not fully depreciated. So one of the things you want to look at is what is your annual cost to how much you're actually setting away. Okay, who can perform a reserve study? Well, technically the community manager can. We don't recommend that. A lot of liability, and of course there's the expertise involved. Harry in Unit 3B, again, as long as they have the expertise, they're welcome to do it. But chances are, if they don't do it for a living, they don't have the proper insurances. So you want to make sure that whoever visits your property, they have the proper insurances, workers' compensation, professional liability, general liability, etc. Now we talk about the site visit, which is a physical analysis. Once we do that, we give you a component inventory, which is going to list all of the components, life expectancies, etc. So you have a clear understanding of the components you're responsible for, how long they last, and their general cost. If you're not familiar with a component, most of them come with a condition assessment and a photo delivery. So you can see what that component is and its particular use. Then we get into our funding analysis. And you see here, we have our expenditure schedule, often known as a component replacement schedule, but this identifies the component replacements. As we've talked about, it varies greatly. So some years it's very high. I think our high year in this particular scenario is 2031 at 500,000, and sometimes it's low. In this scenario, 2019, it's $0. That's a rarity, but you can see it's going to fluctuate. So the idea is to take this expenditure schedule based on the evaluations and you slide it into your funding plan. So you see those component costs are exactly to what your liability schedule is. And then that helps you determine how much money is going to be necessary in each of those determining years. So we talked about our funding limits before, and they still apply. And the issue is that if you're behind in your reserve funding, you can catch up pretty quickly. So in this scenario here, we see that our operating expenses are $90, our reserve contribution is $10, so a total assessment. Well, we can increase that by 20%. So that means $20. And assuming that the regular assessments of the operating budget go up only a few percentage points, you're talking 18 to 19% total increase, maybe $18 to $19 in this scenario that you can apply towards it. And then, of course, you can apply the special assessment as well, and you can do this each and every year. So you start at $100, you go to 120, 144, 172, and in year 4, you're 112. So you've more than doubled your assessments in a 4-year period. So you do have the capability as a board to increase the assessments to make up for lost time. Never day raises dues vistas. This shows you what happens when you follow the advice of when I was on the board, I never raised dues. If you've been in any homeowner association meeting, you've probably heard that phrase. And the problem with that is it leaves you underfunded. So you see here, the association at the top, they got total assessments is $100, operating expenses are 90 of that, the reserve contribution is $10. So of course, that's the board, they adopted that budget. All right, and then a year goes by, and Mr. I never raised dues got elected because unfortunately, sometimes these people win elections. And we're not going to increase our assessments, right? So while we have the increase to our cost, they increase every year. Remember inflation, right? So now our assessment, the recommendation is $103 from our people, of which $92.40 goes to the operating and $10.60 goes to reserve contribution. But they've adopted $100 as their total. Now, the question is, does anybody know what happens if you stop paying your landscaper? And does anybody know what happens if you stop paying your insurance premium? And last but not least, do you know what happens if you stop paying your water bill? Well, the same thing happens in an HOA that happens at your own house. They stop cutting your lawn, they cancel your insurance, and they turn off your water. Yeah, So guess what? They don't do that. They pay their operating expenses. So they pay their water bill, their premiums, and everything that's needed, and then they take what's left over and they put that into the reserve fund. In this scenario here, in the second year, it's $8.60, which of course is less than the $10 in recommended. And then the next year, it drops down to $5.60. So you can see it doesn't take but a few years to fall drastically behind in your reserve funding. Again, the association can adopt whatever funding plan they want. They just have to give that to their membership, and they have to adopt it at an open meeting so that there can be discussion should somebody have an issue with the adopted funding plan. Back to this. Okay, so the reason that this is so important is, one, it saves you liability. As I mentioned earlier, if you have this document, then you're protected because it tells the association potential purchaser all of the relevant financial information. Now, what happens if you're one of the thousands of HOAs that don't have a reserve study? Well, good news for the realtors on a liability perspective is there's just a waiver in the standard contract that says, hey, I understand the reserve study is a very important document, but this is an awesome 3-bedroom, 2-bath in a great school district, so I'm just going to go ahead and buy blind. Yeah, I'm going to buy it without this important financial information because that's what I want to do. And that's fine. That protects the, the realtor from liability. Now, what it won't protect you from is the lack of referrals. Yeah, I've been doing this a little over 20 years. I meet literally hundreds of people a year who pay these assessments, some special assessments, some large increases to the regular assessments, and none of them have been too happy with their real estate agent once they find out about these issues. So while they may have signed that waiver and they don't have any liability, or the realtor doesn't have liability towards them, they're also not going to get any referrals from that client either. I know, I've met these folks. So the best thing that you can do for yourself and your clients is to make sure that they have a reserve study, that this important document is there as part of the transaction, and so that they can see all the important issues, and that you can include it in the negotiations in the process so that people aren't disappointed afterwards. Whether they can or can't sue you, you certainly want happy customers in the end. So in closing, I will reiterate what I started at the top. You want to make sure that your clients get copies of all the important HOA documents, policies, etc., and that they understand them. If they don't understand them, no problem. Tell them to go to cai.org and they'll find a licensed or credentialed professional who can interpret those, whether it be an attorney, an insurance agent, a reserve professional, etc. There are people that will help them interpret it. Obviously, that's not the real estate agent's responsibility. Make sure they understand the use restrictions. Again, whether it's going to be we want to have short-term, or we have rentals, or we want to have pets. Make sure they understand the usage limitations with that property. Make sure they understand the financial conditions, as I just talked about on the reserve study. If they're underfunded on the reserves, you can pretty much guarantee there's going to be a special assessment in their future. So you want to make sure you have a clear understanding of the financial condition of every HOA. And then, of course, as AJ spoke of, you want to make sure that they have the insurance that covers their needs, and you'll have to analyze the HOA's policy in order to make that determination. So you're going to want to recommend that all clients speak to a licensed a licensed insurance agent before making a purchase in an HOA. And with that, we are open. By the way, references, if anybody wants to know the information that we included today, it is part of the Davis-Sterling Act. You can also go to ledgeinfo.com. I have no social life, so that's my favorite website. You can also go to caionline.org. CAIOC.org is our local chapter. And by the way, we have this presentation on PDF. It has been given to CAR. So all you have to do is let Cassie or the group know, and they will give you a copy of this wonderful PDF. So with that, we are complete. I will be around for a couple more minutes if you have any questions, because miraculously, we have 4 minutes to spare. Other than that, thank you all very much for your participation. We really appreciate it.
We had one question, Scott, from Joyce about where can we obtain the handbook? And is this something for our buyers to have as a reference? I missed which handbook she was asking about.
Yeah, the handbook that you're talking about is the Condominium Blue Book. You can buy it on Amazon. It's about $18. Again, it's a great investment for those that sell a lot in HOA. So as a professional, I'd recommend that you have it. As far as a homeowner, probably not important. The most important thing is that they have copies of their documents. The civil code is good information if somebody's violating it, but it won't do you a whole lot of good without it. So I wouldn't recommend it right off the bat for an association member. However, for those that are involved in association leadership, if you volunteer as a member for a board or a committee, then it would be a good idea to have that document as well. But yeah, it's 20 bucks on Amazon. By the way, plug. If you come to a CAI event, a lot of the law firms give them away. So if you want to come to a CAI firm and see us speak in person, plug. I'm speaking in July. You can probably get one of those copies for yourself for free. One last plug before we go. I wrote an article in this month's Orange County Realtor called HOA Deal Killers. So if you have not read your magazine yet this month, please look for that article. A lot of what we discussed today is used as examples in that particular program. And that would be a good thing to share with your members who are considering purchasing into an HOA. Oh yes, AJ put the davissterling.com. That's a law firm that has the Davis Sterling site. Ledge Info will also have that. So if you're looking for a section of the Civil Code, you can easily research that and just pull that up. I think as we've talked about, section 4225 and 5200 are the most relevant for your profession because they talk about the documents and the availability to obtain them. Okay, as they noticed in the chat, the email will be, the presentation will be sent out to you. If you have any questions, again, myself, Diane, AJ, we're all listed on the CI website. If you have any questions, don't hesitate to give us a call. Be happy to answer your questions. Thank you so much for your participation. You enjoy the rest of your day.